I'd like to thank the organizers at Zaytuna University for accepting our paper. As it has been mentioned, this paper is co-authored by Dr. Mohammed Shawqi and Professors Mohammed Minshaw and Mohammed Saeed, faculties at Naif Arab University for Security Sciences in Saudi Arabia. Basically, I have from 10 to 15 minutes for my presentation. I will try to get to the point in this hot topic. I apologize for not switching on my camera because the internet connection is very slow at my end. In fact, as it has been mentioned by many speakers today, the issue of assigning criminal responsibility in cases involving artificial intelligence entities has become increasingly complicated. The complexity arises from the multitude of stakeholders associated with these emerging criminal scenarios, including the owner, the user, the programmer, and even the artificial intelligence entities themselves. The potential involvement of third parties adds a layer of confusion, especially in the absence of specific legal guidelines addressing these novel criminal situations. Consequently, the challenge of determining accountability for crimes stemming from the utilization of artificial intelligence entities has come to the head of the debate, and scholarship and many scholars and many researchers worldwide are trying to determine the accountability for crimes stemming from the utilization of artificial intelligence. For these reasons, the authors of this paper, we have chosen to distill these approaches in three key concepts. The first one is the accountability of the individuals representatives. This means the owner, the user, and the programmer of the artificial intelligence. The second issue is a new theory that is being applied in Europe, especially in France, the theory of prospective liability. And the third theory is the theory of direct liability for artificial intelligence entities themselves. In fact, the question of whether artificial intelligence entities can be held criminally accountable raises complex legal and ethical considerations. As of now, AI entities themselves can't be held directly responsible for criminal acts. AI operates based on programmed algorithms, as we all know, and lacks the intent and the free will required to establish criminal accountability. And instead, the responsibility can be attributed to human beings according to all the theory of criminal law, which has been mentioned by one of the authors today. And humans involved in the development and utilization of these AI entities can be held responsible. In cases involving criminal use of AI, the responsibility primarily lies with the individuals who employ AI entities for illegal purposes. These individuals bear responsibility for their actions, and they can intentionally manipulate the AI's capabilities to commit crimes, and accordingly they will be considered responsible for the criminal acts. Organizations or individuals involved in developing and deploying AI programming can also share liability, as we will see later on in this presentation, and they should ensure that appropriate measures are in place to prevent the misuse of AI technology and may be held accountable if they have recklessly contributed to the creation of AI systems that facilitate criminal activities. Please put in mind that the general rule is that only humans are legally accountable, and this rule is one of the fundamental concepts upon which modern criminal legislation is built. In the absence of the concept of independent artificial awareness of artificial intelligence entities, and that's the major problem that we currently face in the courts, especially in the United States and in Europe, in the absence of independent artificial intelligence awareness of everything, discussing its criminal liability becomes very, very complicated. But this doesn't imply the absence of criminal liability rules for the criminal consequences of its activities, because the legal character of artificial intelligence entities continues to make allocating criminal liability to these entities very challenging. The problem is that crimes committed by artificial intelligence entities without external intervention or technical penetration are very complex and is imagined with machines controlled and driven by robots rather than human beings. This would transfer the element of actual control from human beings to artificial intelligence entities, and this includes making decisions related to the process being implemented. Nowadays, we are talking about machine learning. We have new generations of robots that can think and that can take decisions independently from human beings according to the algorithms inserted in them and according to their programmer. Therefore, criminal court decisions present some concepts and theories that can be used to establish criminal liability for the usage of artificial intelligence entities. These perspectives, as I mentioned in the beginning of my presentation, are divided into three main theories. The first one is a person in charge. This means the owner, the user, or the programmer. The second one is a theory of prospective liability. And the third theory is a theory of direct liability on the part of the artificial intelligence entity itself. And we will examine all these three theories in my presentation. So we will start by the first theory, the owner, the programmer, or the user who produced, who created, or who used the artificial intelligence machine, or who provided it with the artificial intelligence program. This person bears full liability. Legal individuals who use these entities may likewise be held liable according to criminal law and according to some court decisions. According to the general rule, the producer may be questioned about crimes and errors caused using artificial intelligence entities, particularly those caused by defects in manufacturing or design or the lack of security systems. And this person may be also questioned about his failure to warn users and inform them of the potential risks and mechanisms for dealing with them, or for the negligence that leads to the crime occurring. And based on the theory of potential liability, if the crime was committed because of negligence in using, operating, or manufacturing the artificial intelligence entity, the representative can be held accountable for those unintentional crimes such as negligence that causes damage or death of a person. And we have an incident that happened some years ago in Europe that a robot killed his programmer or his manufacturer, and this raised questions in the court about the criminal liability of this robot and whether the programmer was accused in manufacturing this robot or not. The moral actor doesn't directly commit the act that comprises the material part of the crime, but rather employs another person of good faith or machine to do so. And comparative legislation has addressed the concept of what we call the moral actor, الفاعل المعنوي, of the crime, with some explicitly stipulating moral actor accountability, such as the German law, which mentioned this theory in Article 25 of the German Penal Code. And in Arab countries we have also the theory of moral actor, and it has been adopted by several laws, such as the Algerian law in Article 45 of the Penal Code, the Kuwaiti Penal Code, the Iraqi Penal Code in Article 47, as well as the Bahraini and Emirati laws. Now we will move to the second theory, the theory of potential liability. It is assumed that the programmer had no intention or plan to conduct the offense in this case. However, the crime is committed because of an error in the artificial intelligence behavior, and this cause is linked to a flaw in the way in which the artificial intelligence entity should have thought or should have taken a bad decision. And accordingly, the theory of potential liability may be valid in some cases, given that the programmer or the user had the ability to determine the chance of committing the crime, and it was possible as a result of the employment of the artificial intelligence entities. However, the theory allows for the attribution of criminal liability, which can take one of two forms. The first form, a circumstance in which the programmer or the user intends to commit a crime using an artificial intelligence entity, but the latter deviates from the plan and commits another crime. So the programmer has an intention to use the robot or the artificial intelligence entity to commit a planned crime, but this robot commits another crime that hasn't been planned and that hasn't been put in consideration and that hasn't been intended by the programmer or the user. In the second circumstance, the programmer or the user have negligence when developing or when using the artificial intelligence unit. They use it without either of them having the intention to commit a crime. Similarly, if the robot programmer failed to provide safeguards that prevent it from killing human beings or from setting fires, for example. Now, to a new theory and the major question: is it possible to imagine that the crime was committed by artificial intelligence itself without any error on the part of the programmer or on the owner or the intervention on any external party, using modern technologies that enable the artificial intelligence entity to think and to make decisions? The new versions of robots and the new versions of artificial intelligence, according to the algorithm and according to their programmer, they can take the decision away from their owners and away from their programmers. So this theory, according to this theory, is it possible to imagine that the crimes have been committed? Is there a responsibility on the entity of the artificial intelligence itself? In this situation, the artificial intelligence entity is directly and fully liable. This trend confirms legal personality on these entities even though they don't apply to them as human beings. In some countries, there is a general tendency to reconsider the legal adaptation of machines that rely on artificial intelligence by distinguishing them from what we call the concept of the thing that has been applied to them for a long decade, as it has been mentioned today by one of the speakers. Some countries grant the artificial intelligence entities a legal status different from the concept of the thing in law to protect the society from the illegal use of those entities, given that these machines have a tangible physical presence as well as a directed mental existence that cannot be disregarded. Based on this concept, the legal nature of these entities can be determined within the context of ethical and legal principles that highlight the numerous separating lines between them and both natural and legal persons. Finally, in my conclusion, we can say that it is essential to establish strong legal frameworks that clearly define accountability in cases involving AI-related criminal incidents. This doesn't ensure justice only, but also promotes the healthy advancement of AI technologies. We must adapt our legislations, and that's what I always say in my conferences and my presentations. As a cyber law expert, we must adapt our legislations to technology because there is a race between offenders and policymakers and legislators. We must adapt our legislations to face the challenges of new technologies. The collaborative efforts of researchers and lawmakers and AI professionals are very vital for the success of the challenges we face. Our study today represents a step in tackling the complexities surrounding AI and criminal liability. And on such a basis, we have 3 recommendations as authors of this paper. First of all, artificial intelligence entities should be granted independent legal personality. That is very important. Just like legal persons using the term human in command, especially considering the growing European decisions about granting the legal personality to artificial intelligence in its physical form represented by robots and holding it liable for its actions. The second recommendation, AI technology should be used in accordance with professional, industry, ethical, and regularity standards. And finally, clear legal texts must be developed that define the mechanism for attributing criminal liability for crimes committed using artificial intelligence entities, considering the balance between the design, production, and use entities, as well as the level of development that artificial intelligence technology has reached. Thank you very much.
شكرا جزيلا دكتورنا الفاضل على هذا المجهود العظيم، وفي الحقيقة قدمتم إضافة علمية مميزة وتنطوي على مناقشة موضوع مهم جدا يمس وقتنا المعاصر، وقد يكون على نطاق كبير جدا في المستقبل القريب. فلا شك أن مسألة المسؤولية الجنائية المرتبطة بالذكاء الاصطناعي من خلال استخدام أو استغلاله أو حتى خروجه عن أوامر مبرمجين من الأمور المهمة والتي هي على المحك في هذه المرحلة والمرحلة القادمة. وقد تناولتم العديد من الأسئلة الحيوية كما في مسألة محاسبة مدى إمكانية محاسبة الذكاء الاصطناعي، كون نحن اعتدنا على المحاسبة تنحصر في الكيانات البشرية فقط لا غير، ومدى انطباق القواعد المسؤولية الجنائية على الجرائم بواسطة الذكاء الاصطناعي بشكل عام، في ظل أننا الآن ضمن نطاق قواعد تقليدية وقد لا ترتقي لأن تعالج هذه المسائل على نحو واضح